All right, we should be back in the building. On this Wednesday morning, it's hump day in here. Shout out to the gang. Hopefully y'all are doing well. We looking all crispy and clean on the screen on this Wednesday morning. Good to see everybody in here. Y'all know what to do. Drop a 1 in the chat if you can hear me. Drop a 1 in the chat if you can see me, if we're looking good up in here. Welcome back to another YouTube live stream and another episode of the ClassE Morning Show. I'm your host, ClassE, of patreon.com/ClassEbeats, by the way. Link is in the description as well as in the pinned comment in the chat. Y'all make sure you check it out. Today, we are getting into it. This poor Karen Reed, man, I feel bad for Karen Reed. We're going on the 4th day. Is it the 4th day? We say 4. We have 4 or 5. 4th day. We've been in deliberations and it's been absolutely insane. Karen Reed waiting to find out what the jury decides. And we had an amended verdict slip we're going to get into and today, and then we'll do a little bit of a rewind. We got to finish up Proctor's cross-examination because it's just nice to see a corrupt cop getting cooked on the stand. So we'll get into it here in a second. Thank you all for being here. Shout out to the gang. You know I got to say what's up to the people this morning, though. Shout out to everybody who's in the building. You know, of course, we have to give props and shout out my amazing, awesome Amy is up in here first thing in the morning, reminding y'all to like the video. We got Les Cleaver in the building. Taco Tuesday is in here a day after Taco Tuesday. We got Kara Hampton, Jay Buckmaster, Slim Life, New Jersey, Ingrid, Mr. Brown, my dog, Libby22, SC Girl is up in here. We've got D, CPE, my dog is in the building. What up? We got Perfect Peace is back at it as well. Oh, hold on. Whoa. Chill. It's getting me way down. We've got Perfect Peace is in here. We've got Lady E is in the building. Good morning. I see everybody's up in here. We've got Penny Neal. Good morning. We have, who else? Shout out to Trisha is in here. Ocean Grove, Keep It Moving, New York. Good morning. I got to give y'all another round of applause. We've got Paua Eyes is in the building. Good morning. FNN Agent is in here. FN Agent 84. We've got, well, there's so many of y'all in here. Appreciate everybody who's watching. I think I got most of you. If I didn't, make sure y'all harass me and say, you missed me. Because I want to make sure I say hello and good morning to everyone. Just Diane is in here. Good morning. Cynthia Hartz is in the building. Good to see y'all in here as well. All right. I'll be saying good morning to y'all as we go throughout the show, but I know you guys are here for the content. You want to get into it. Before I get started, I have to ask, I have to absolutely beg you guys to like the video. I ask every single show and I'll be asking until I get off of YouTube. It is one of the ways that you can support the show, and I appreciate everybody who's liked the video already. So if you could take a second, like the video. It's free. It takes less than a second. It lets the algorithm know you guys are enjoying the show. Shares the video, the channel, this live stream, and past live streams and videos with more people. So thank you to everyone that's already done that. Also, if you guys are feeling super generous today, you can share out the video. You share the video. That's another way to help the channel continue to grow. Also, I will be reading super chats as we go throughout the day as well. So shout out to everyone who sent in super chats already. Oh my gosh, y'all are going crazy up in here. So let's go ahead and get into it real quick. We've got Les Cleaver is in the building this morning. First thing, he says, good morning all. And we will have a verdict today, in my opinion, and it will be not guilty. We can only hope. Have a great day and God bless you always. Shout out to Les Cleaver. We've got Libby22 SC Girl in the building with the 5 bombs. Says ClassE, Amy, and CEB family. Today has to be the day. I hope so. I love y'all. Oh my goodness. CEB is the absolute best channel ever. Thank you, Libby22 SC Girl, for the love. We've got CPE in here gifting 5 memberships. If you guys got a membership from CPE, make sure you say thank you. Make sure you show CPE some love. Continuing to show up and show support. Thank you, my guy. We got Slim Life New Jersey in here with the 5 bombs. Says good morning, ClassE, Amy, and my amazing CEB family. Everyone have a blessed day, and remember, God is good all the time, and all the time God is good. Thank you, God. Let's get it. Free Karen Reed. Yeah, she's got to go free. She's got to, and we're waiting on it. I hope there's a decision today, and it looks like the majority of you think there will be. I know tomorrow being June 19th, court most likely won't be in session, and I think it is officially a federal holiday. I think Biden did that, if I remember right. Anyway, so there won't be court tomorrow. If they don't come out with the verdict, it's going to be Friday. We'll be going a week with no decision, which would be crazy. Either way, we'll see what happens. Trisha's in here with a 6 month, has been a member for 6 months. Dang, Trisha says, good morning, ClassE, Amy, and CEB family. I hope everyone has an amazing day. Excellent coverage, ClassE, as always. Thank you. We don't miss. Keep up the great work. Thank you for being here. And then, of course, we've got my awesome, amazing Amy is in here gifting 5 memberships. Again, when y'all see someone gift those memberships, make sure you show some love and say thank you. All right. People are over here showing love, giving you guys an opportunity. Check out members only content, get that green highlight on your name, and a bunch of other things as well. So shout out to Amy for always showing up and supporting. I appreciate you. We've got Virginia Wiley in here with the 5 bomb. She says, good morning, CEB family. In case you haven't been told today, you are beautifully and wonderfully made. Be great. Oh my gosh, these super chats are amazing. Thank you, Virginia Wiley. And thank you for becoming a member over on the Patreon yesterday as well. Paua Eyes is in here with the 2 bomb and that adorable puppy in that profile pic too. Is that your puppy? Oh my gosh. Giving me puppy fever over here. It says, have an amazing day. Good luck, Karen. She's going to need it. She's going to need it. But I think the jury, we have, if we use our context clues, we can kind of see what the jury is thinking. And again, guys, I've served on the jury. Many of you who are in the chat have served on the jury as well. And I think generally, especially with a case like this, you can have a pretty good idea of what the jurors are thinking based on the questions they're asking. And we saw them asking questions about section 2, which we're actually going to get into. And that was the manslaughter section. Why are they asking questions about the manslaughter section? They made it clear. They're asking because they're not sure about what was going on with her alcohol levels. What's the time frame on the alcohol? Are we talking about at 12:45 or are we talking about when she was actually tested before? Do we have evidence to that? Are her statements about how much she was drinking, are those going to be taken as evidence? How much weight should we give those statements? And so on and so forth. They're not asking about murder, probably because they say, hey, the blue paint ain't did it. We're good on there. They're not talking about the 3rd count, which was her leaving the scene of an accident resulting in death. Like, what? We need to find out and figure out and know what's happening with this whole alcohol situation, because that's going to be important. So if they don't have questions about the 1st, they don't have questions about the 3rd, I can imagine they're focusing on the alcohol. Okay. Or could it be maybe they're focusing on the section 2 because they're trying to decide if she was drunk while she hit John? That's a possibility as well. I also don't think that's the case. Based on how the cases were presented, based on what we've seen so far, I can't imagine a jury wanting to convict her of murder, but crazier things have happened. Casey Lee is in here too. Good morning, Casey. Good to see you in here. We've got Vintage Galleria's back at it. Jay Bird's back in here too. What's up, Jay Bird? Jay Bird, are you? My memory is so bad, but Jay Bird, I think you're the one that said you're going your 1st year in law school, right? So shout out to Jay Bird for taking the jump and getting into law school. I think it was Jay Bird. Tay Toom's in here. All right. We know Tay Toom's going to be in here cutting up. Also, shout out to Amy for letting y'all know how to make sure you get your memberships taken care of. All right. So we've got a couple things we're going to get into, and we'll go ahead and start court because we've got Judge Bev. You know, she's going to start off with our BS. And then what we're going to do after that is we're going to look at the amended verdict slip. So we can go through that. I want to get you guys thoughts on what the updates were, if you think they were effective, if you think they were worded correctly, and how that's going to affect Karen Reed's verdict. All right. So let's go ahead and get into it. Let me make sure this is good. We're all set. We got to share this out real quick and let the people know that we're live. And again, thank you to everyone who's liked the video. Over nearly 600 of y'all have hit that like button so far. And I've been up here talking for the past 10 minutes. I need to chill out. All right, here we go. Let's go ahead and get into it. Hopefully we get, I don't know if we're going to get any hear ye today. But hopefully we'll get some hear ye. No, I'm going to be a little disappointed. We got the only fan. Taysa, I'm gonna try and behave, man. Please. Oh, forensic scientist. That's what it was, Jay Bird. Thank you.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Canoni, the Justice of the Superior
My God,
Court,
don't miss.
now holding in Dedham within and for the County of Norfolk. Draw near, give your presence, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
All right. Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors.
Here we go with the cap.
Those same 3 questions before we send you back out to deliberate. Was everyone able to follow the instructions and refrain from discussing this case with anyone since we left yesterday?
Yes.
Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case?
No.
Everyone said yes or nodded affirmatively. Did
Jurors
anyone
be
happen
lying.
to see, hear, or read anything about this case since we left yesterday? Everyone said no or shook their heads. Well, with that, Mr. Foreman, thank you all. We're going to send you back out to deliberate.
All right, please.
All right, and I don't think we have anything to report today. No questions. I would say we can only hope that they go back during deliberation and get this figured out. But we thought they were going to have it yesterday. I thought they were going to have it on Monday. But man, this is wild. So now that we got that out of the way, let's go ahead and get into this amended verdict slip. And shout out to Kathy Russin from Law and Crime. She was the first person I saw that posted this and has been doing amazing work covering this, as well as the entire Law and Crime team. So shout out to them. Amy says she had some insight that they're all dressed up again today. They were dressed up supposedly yesterday. So maybe these jurors just dress nice. Who knows? But if Amy says it, I'm going to take it. I'm going to take it as a point that should be noted. So let's see what this verdict slip looks like. We've got number 2. Now, this is just number 2. Nothing changed in count 1, which was the murder in the second degree, and then count 3, which was the leaving the scene of a crime, or leaving the scene of an accident resulting in death. And we're going to look at the old verdict form here, our verdict slips shortly. But what do they say? Offense 2, manslaughter while operating a motor vehicle under the influence of liquor. In the above entitled case, we, the jury, say that the defendant is, here are your options: not guilty of the offense charged or any lesser included offense. Now, here's the update in parentheses. If you find the defendant not guilty of the offense charged or any lesser included offense, stop and sign the verdict slip. Interesting. So that's going to be something that I think the jurors are going to be happy about. Now, again, they didn't finish deliberating yesterday, so maybe they're still going back and forth about something. Who knows? All right, number 2, guilty of the offense charged. Y'all know manslaughter while operating a motor vehicle under the influence of liquor. Check one or both of the following, or you can check number 1. Also, we have a note here. If you find the defendant guilty on manslaughter while operating a motor vehicle under the influence of liquor, stop and sign the verdict slip. If you find her not guilty of manslaughter while operating a motor vehicle under the influence of liquor, then continue below. This is how it should have been in the first place. I mean, or we could have just added guilty, not guilty, but whatever, complicating things as the Commonwealth likes to do. Guilty of lesser or included offense, or lesser included offense, involuntary manslaughter. Again, if you find the defendant guilty of the lesser included offense of involuntary manslaughter, stop and sign the verdict slip. If you find her not guilty of involuntary manslaughter, then continue to the next page. Next page says, guilty of the lesser included offense, motor vehicle homicide. It's a felony, OUI, liquor, and negligence. Check one or both of the following: motor vehicle homicide under the influence of liquor and or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08 or greater. All right. Also, we have this note again. If you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony OUI, liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of the motor vehicle homicide under the influence of liquor, then continue below. Okay, so we're taking it step by step by step. I personally feel like this could have been way simpler than Judge Bev put it together. Can we just have a not guilty option for every point? Again, I'm not an attorney. I'm definitely not a judge. We'll let it be. We're here. Let's keep it moving. We've got guilty of the lesser included offense, operating under the influence of liquor, which I think personally has been proven beyond a reasonable doubt, and she should be found guilty of. What did they say? The options are check one or both. Was she operating a motor vehicle under the influence of liquor, or was she operating a motor vehicle with a blood alcohol level of 0.08 or greater? Now, this is an interesting thought because we had a lot of back and forth about this in the chat and in the comments as well. We have to distinguish something here because a lot of you, I think, are getting caught up on this second point under 5, the blood alcohol level of 0.08 or greater. I'm saying that it seems very, very clear to me that she was operating a motor vehicle under the influence of liquor. And we've seen evidence of that. She admitted it in interviews. So I think at least minimum, she should be found guilty of operating a motor vehicle under the influence of liquor. It's not that complicated. But then again, you guys, I know we're focused on the BAC, we're focused on the BAL. You're focused on this second part. I want to see now that we've distinguished the two, if you guys feel the same. If you say, oh, okay, well, operating a motor vehicle under the influence, I'll give you that one. Or you're still saying, nope, there's nothing. I haven't seen the evidence beyond a reasonable doubt that shows she was operating a motor vehicle under the influence of liquor. Y'all have to let me know. Either way, if you find the defendant guilty of operating a motor vehicle under the influence of liquor, stop. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1. Interesting. So this is a different update. So I think this is worded in a very favorable way for the defense. So they're basically saying, if you find the defendant not guilty on this offense and all other offenses, then check the first box on page 1. So they leave no doubt. So if you find her guilty of not guilty of 2 through 5, just go ahead and say, I'm going to check off number 1, say not guilty on all offenses. But with this being the last one, and seeing as you would have stopped at some point in 2, 3, 4, and then signed if you thought she was guilty. Now that we made it to 5, you can check this one, stop, sign, boom, move it forward. All right. I think this was a good update. I think this was well done. Makes a lot more sense. And if y'all want to see real quick, I'll show you guys the verdict slip here. And then I'll read some of y'all's comments to see what you think about this. All right. Hopefully, Adobe doesn't expose me that I hadn't paid for Adobe Reader. Not that you have to. Let's go and look at the differences. Now, this was the difference between the first one. This is the first and the initial page 2. And here's what it says. We don't have all the qualifiers. We just have not guilty. We got the first offense. We've got the second, third, fourth, or number 5, which we like to say. And this was confusing and not laid out as well as it was here. This is a lot more step by step. Take it 1 point at a time instead of, hey, just look at all this guilty stuff and then not guilty here. No, I think they did a good job. I think it was a good update for the defense. Maybe there's something there that I missed that could have been included. You guys will have to let me know what you think about that in the comments and in the chat. Let me see what y'all are saying. How do you feel about the updated verdict slip? I think they did a good job. I think this is written very well. And now the jurors can take it 1 point at a time. Let me see what y'all are saying. I saw a couple people in here that I missed, and I misspoke about our forensic scientists in the building. And I apologize for misidentifying your profession. And the teacher too, that's super dope. Where'd Jaybird go? There she is. Jaybird says, I'm actually a forensic scientist, a clinical lab technologist, and a high school teacher. Wow, shout out to all the amazing teachers out there. Witchy Bishy is in the building. Thank you for being here. Good to see you. Danny in real life is in the building in blue. I cannot remember if I shouted you out, but shout out to all the members in here. And Amy, as I mentioned, said they're all dressed up. They wanted to go home yesterday so they could find out what will happen. Oh no. Hey, don't say this. Shout out to SGT. So they wanted to go home, or they wanted to go home yesterday so they could find out what will happen if they find guilty on OUI because Bev won't tell them. Dang. Yo, this jury be lying, man. You know, I'm laughing because SGT, you're probably right. That's hilarious. You got to get the foreman on the show. Yeah. Hey, foreman, if you're watching this, I know you are. If you're watching this, or you watch this after you guys are done deliberating and deliver the not guilty verdict, let me know if you want to stop by the show. And shout out to the UK in the building. Curious Coco, that's who it was. Curious Coco New York is in here. Said hoping for a verdict before lunch today. Me too, because I don't know if I'm gonna make it after lunch, y'all. I'm gonna be honest. Casey Lee is in here as well. Good morning. It's strange to me that there isn't a standard verdict slip that can be edited per case. These are basic instructions that should be on every form. No, well, Vintage Galleria, I mean, in this case, you think about it. If you had Karen Reed, she was at the waterfall, right? And she took her car and then she drove it through the front of the building at the waterfall. And then they didn't find out about it till later. Then she picked up John. She's like, hey, John, let's go to this party. Then she drops John off at the party. And according to the Commonwealth's theory, John gets out of the car. She goes backwards and hits him at 20 something miles per hour. He flops over, he dies, right? And then Carrie comes out of the front yard. She's like, oh, what are you doing? Carrie pulls forward and hits Carrie, and then she's got to back up. There's just so many factors, and each case is so different. You can't really have a standard form. Like, unless people are just out here shooting and killing people in the same exact way, you can't really, it's so specific to each individual case. Because one thing changes is going to change not only the type of charges that are there, but it's going to change how they're listed and how they're connected to each other, right? For example, the manslaughter offense. With every manslaughter offense, there isn't always going to be alcohol. With every manslaughter offense, operating a motor vehicle while under the influence, there aren't going to be these 5 points every single time. So I say all that to say, it's just different sometimes. The first one, because no BAC. Oh, okay. So Dawn, it seems like, because yesterday, Dawn, I think you were saying that no, she should be not guilty on number 5. So now let me know if I'm making a mistake and I misremembered. I thought you were saying no on number 5 and not guilty on number 5, period. If there was an accident, by law, they have to test when you are pulled over, or something, not just, oh, we think you did something, let's take your blood. KC is in the building too. Shout out to KC. Buenos morning all. This trial reminds me that it's strange to see a clown being a ringleader of the circus. Oh man, that's great. Amy says, 1, the charge can only relate to driving around 12:30 a.m. on January 29th, 2022, not 5 a.m. Yeah, we heard that yesterday. I think they said, 12:45? Because they've changed the timeline so many times. Anyone leaving a bar is under the influence of liquor or a restaurant is too general for me, I think is what you want to say. The definition of under the influence of liquor is too broad. Then don't get in a car after one of these. Stop driving. Problem solved. I don't disagree with you that it's broad, but guys, it's 2025. The Uber back to her house was probably less than $10. Anyway, I still say no because they charged her for the murder that they knew the mafia committed. Oh man, Dawn, come on. You're better than this, Dawn. We're focusing on number 5. Is she guilty? Guys, type a 1 in the chat if you think Karen Reed is guilty of operating a motor vehicle under the influence of liquor. Type a 2 in the chat if you believe she is not guilty. I'm just trying to make it as simple as I can, but there has to be proof. 50 people in the chat here could admit right now to driving under the influence. That's not enough. They weren't caught at the time. They were caught on video. That's enough proof for me. Shout out to Nano Banana up in here. Has been a member for 7 months. Says good morning, ClassE Beats, Amy and gang at the airport. Just checking in. Have a safe flight. Nano Banana, thank you for stopping by. All right, so I see a lot of 2s. Y'all are saying not guilty. Paua I says ClassE, look at legal, not moral. Legally, she was driving under the influence. It's on video. She's taking 1, 2, 3, 4 shots. And then she got in her car and left. Then she admitted to it to the police, to multiple witnesses, and did an interview where she talked about it. I don't know what else I don't know what else you guys need. I'm going to remove myself from this conversation. I'm going to let y'all have it. 1, no direct police observation at the time. 2, no field sobriety test. 3, BAC is retro. 4, could have consumed after driving, but before the BAC. When you make it home drunk, no cop better knock on my door. I ain't driving. Why you here? KC says 1. So KC thinks that she's guilty. 1, but yeah, they didn't prove that. Interesting. I don't think she's guilty based on BAC, but she is based on her own admission and video. There's video. I don't know how we're just moving past the video of her drinking and then getting in the car, but 2, they haven't proved it beyond a reasonable doubt. So 2, 2, 2, 1, 1, 1, Raunchy Dog 1. Jose is in here with the 1. We've got Dante, good morning, with the 1. I guess we see why they're hanging on this point. Yeah, and that's Raunchy Dog, you're jumping ahead. That's what I wanted to, that's the point I was going to make, is we see 1, 2, 1, 2, 1, 2, 1, 2. This is why we've been here for 2 days. CPE says 1, she admitted it, but what can they do to her since she wasn't caught? Legally, she admitted it on video, says Witchy Bishy. The BAC should not have been admissible. I agree, especially if they're going by the 1245 timeline. That's really tough, but I have to say too, because there's no evidence, like actual evidence. Oh, so y'all think it was lemonade in those shots? Oh man, y'all killing me. I agree. The lore is the lore. You spelled it wrong, Casey. I'll admit to also driving drunk in the past. I don't think I can now be charged though. Correct. She probably was drunk. It's not drunk. It's just under the influence. What is the definition? And Amy sent me a link to X, something that she posted. So I'll read that in a second. Let's see. In Massachusetts, what is the legal definition? It says y'all might change my mind of driving under the influence, and how is that measured? Here we go, guys. Said the lore is the lore. Don, ClassE, put yourself in her position. You get charged with a murder that you had nothing to do with to cover their friends. What does that have to do with driving under the influence, Don? Legal definition of OUI in Massachusetts. A person is guilty of OUI if they operate a motor vehicle on a public way while under the influence of alcohol, marijuana, narcotics, depressants, stimulants, or intoxicating substances to the extent that their ability to operate the vehicle safely is impaired, or They have a BAC of 0.08 or higher, 0.02 for drivers under 21. What? How it's measured? Breathalyzer. She didn't take that. Field sobriety tests. Blood and urine tests. Important notes. Refusing a chemical test leads to an automatic license suspension under Massachusetts. Oh my goodness. Implied consent law, even if you're not convicted. Actual impairment can still result in a conviction even if the BAC is below 0.08 based on police observation and field sobriety test. Is it and observations and field sobriety test or not? This is a tough one, guys. I'm not willing to budge on this. So we see now why the jury's still in here. Everyone was hammered and getting pulled over with your cop boyfriend in the car. You get a get home safe and a pat on the back. Let's see what Amy says. She's putting the face palm emoji, so I need to read this. Strong reasonable doubt arguments are factual and based on items and evidence. The jury must acquit of OUI, says Amy. This charge can only relate to driving around 12:30 a.m. on 1/29/22, not 5 a.m. That is logical. 2, the Commonwealth cannot prove she didn't drink more alcohol between 12:36 a.m. and 5:07. This means the retrograde test results are inconclusive. Massive reasonable doubt. Serum blood testing was done. Whole blood testing is more accurate forensically as argued by the defense. Massive reasonable doubt. Defense argued testing results were skewed as they did not factor in Karen's MS health issues. Massive reasonable doubt. 5, the state has the power to charge her separately with the misdemeanor OUI like any other citizen. Massachusetts, you can be convicted without a BAC, plus her BAC was a medical blood test, not admissible in court. I agree with that. OUI has a minimum of 2.5 years in jail, but first-time offenders get probation. If convicted, Bev will probably get the max, but she can always appeal. All right, so there's Amy. She just posted that over on X. If y'all don't follow her, make sure you follow her on X. I'm not gonna have a hung jury on this, but dang, man, I'm not convinced, guys. Where's Dawn at? I want to see what Dawn said. And as an alcoholic, get help. No, I'll play witchy bishy. I think there is an issue here. I think the issue here is how casually they all drive after drinking. It's scary, absolutely terrifying. Legally, but she got home. They can't charge her. They saw on video she was drunk, but they didn't pull her over while driving. I'm completely disinterested in her sobriety and more interested in the crime, which she's innocent of, in my opinion. An interesting conversation to have would be, what else triggers a breathalyzer besides liquor? You probably said that before I read what it is. Let's see, for commercial drivers, it's alcohol, marijuana, narcotics, depressants, stimulants, or intoxicating substances. Molly, I guess. To the extent that their ability to operate the vehicle safely is impaired. And also, 2 major highlights are hand sanitizer and mouthwash. Anyone think Karen might have brushed her teeth? That was crazy. Who served her? How much did she drink? Who testified to her consumption? We've got Slim Life New Jersey in here with the 5 bomb. Says, but are they worried about the time of the BAC because they did not believe there was an accident, but they can't agree on if she was drunk at the time. I think so, because I can't agree. That's what scares me. And she doesn't have to be drunk. She just has to be under the influence. If they're, and shout out to Def Defy, if they're going to charge Karen with driving under the influence, they got to charge Jen's husband, Higgins, and how many others? They all admitted on the stand to drinking and driving. Let me see. KC says, ClassE, that's like admitting I took drugs last week with the video. You can't be charged with possession after the fact. Are you sure about that? Are you sure? You sure? DWI is the crime, Amy says, of operating a motor vehicle while impaired by alcohol or drugs to the extent that it is less safe to drive. The impairment can be due to alcohol, drugs, including prescription and illegal drugs, or a combination of both. Most states use a blood alcohol concentration, a BAC. How did the rest of them get to the Alberts? I'm guessing at least one person was drunk driving. What was the possible cause for the BAC extrapolation? What do you mean? Let me see. Are you a I don't know. Under the alcohol or under the influence is too broad. DUI is what requires facts. If you have one beer at Chili's and then drive home, you're driving under the influence. Are you drunk? No. Yes. I agree. But then driving under the influence, we went through the definition here. It seems really broad. Again, it says you're under the influence or operating a motor vehicle while under the influence of these substances to the extent that their ability to operate the vehicle safely is impaired. I mean, she did back into John's car. She was driving kind of crazy. I don't know, guys. Do you know how many people are driving around on Xanax? I don't want to think about it, guys. Jeez. Oh my gosh. And shout out to y'all are sending in some super chats too. I need to read these. Dawn. Oh, there's Dawn. Dawn says, because they put her through all this hell to cover the truth. I get it and understand, but OUI, they can't prove. Hey, you might be right. I don't know. I've just seen enough to say I think she should be charged with it beyond a reasonable doubt. Cynthia Hartz is in here with the 5-bomb, says, was it on the first indictment? If you drive home under the influence without incidents, it is a moot, I think I meant to say, point. She did not hit him. Thank you for the super chat, Cynthia. Yeah, what evidence do they have? You guys are saying there's not enough evidence. Some of us are saying we think there is enough evidence. I don't know. Curious Coco, New York, in here with the 5-bomb, says Karen Reed wasn't driving at 5 a.m. She was in the car with Carrie and Jen when she tested .09. They can rule not guilty on OUI if they consider the timing not 12:30 a.m. Amy agrees with Don. For instance, I only use 6 feet of my intestines, so things flow quicker. Meds don't fully absorb in my system. Let me see. What else are they saying? But everyone has to understand that there are outside things that can trigger a breath test. Yes, that is true. Yeah, moot. Thank you. I got you, Cynthia. Karma's in here. Says, so shouldn't all of them be charged? Yes, absolutely. Also, thank you to whoever gifted me a membership. I really appreciate you. Thanks for being here, Karma. Even she didn't hit him. They messed everything up. So I don't see how they could convict her. Just my opinion. Karen cannot be found guilty on OUI just because she said she was drinking and because she's on video drinking and because She ran into the back of John's car. Okay. And drinking and driving isn't enough. What? There was no sobriety check. She was never cited by a cop. No cameras were working in the town of Canton the night, especially on Fairview, and the hospital test was not forensic alcohol test, which has different values than a hospital BAT. She is not guilty. Oh, man. Let's see. And is there something, did y'all say there's something going on in court? Let me double check and make sure we didn't miss anything here. I don't think there is. I think we should be good. Yeah, we're good. And I need to relocate this. This is an interesting conversation. And I think we can kind of see what's going on. Also, Amy says, she sent me a post that says, my sources tell me that the jurors today were dressed in anything but loungewear. Up until today, they were wearing more casual loungewear. Today, they are dressed for success. It's almost as if they're expecting to reach a verdict today based on their clothing. Didn't they say that yesterday? Ugh, I don't know. So if they come back hung, will the defense be able to ask the jury to be polled about the charges? And can she be found not guilty of some of the charges? That was the thing they weren't allowed to do the first time. That's a good question. We have some of our resident attorneys in here. I will let them answer that question. ClassE for president, Amy for VP. No, I'm good. I'm good on that. But I appreciate the sentiment. Amy, you want to be president? She's not gonna. No, she's gonna tell me I have to do it. She's gonna say, no, you'll be the all right. Fine, I'll do it, guys. I'll do it. 2028, we'll make it happen. So if there's hung jury on one, they're hung on all of them, right? Oh, well, that's going to be a problem. That's going to be a problem. And as you guys said, there was confusion with the jury the first time, from what I understand, because they said, hey, we've already found her not guilty of, I believe it was count one was the murder charge, murder in the second degree. But we weren't sure about the second charge, and there was issue there. But they didn't realize that they had the option of finding her not guilty on one and undecided on the second one. Yeah, so it's, I think now things are pretty clear. So if they get hung up on this one, the only thing that she would be able to be retried again was the manslaughter. That's my understanding. Again, guys, with my limited knowledge, not an attorney, take that for what you will, do your research. But from what I understand, if they find her not guilty on the murder in the second degree, not guilty on the third charge, which I keep saying wrong, so I'm just going to read it. The leaving the scene of an accident resulting in death, and they're hung on the second, then if they decide to retry her, it will only be retried on manslaughter. So hopefully one of our amazing attorneys in the community will stop by and either back up what I'm saying or correct me. Also, we have, what else are we saying? Yesterday, the ladies were dressed up. The guys weren't. Today, they're all dressed up. All right. We've got Kara Hampton in here with the 2-bomb. Says, come on, jury, get it right. Do the right thing, guys. I got busted for OUI at 21, 1 year of probation and loss of license for a year. That was way back. If she gets that, take that. You know better. You should know better. Let's see. What I don't get is if it's the verdict form forcing them all or nothing or the law itself. Good question. Definitely don't want to drive around some of y'all. Hey, Tatum. Hey, man. Y'all better stop justifying this BS. Teach her a lesson. Don said that's what happened last time. Yeah. Lovely says you're right. Yeah. Okay. So Lovely Lily says that is correct. And he says President hung. I mean, hung. With the 2-bomb. Shout out to Amy, who has absolutely No filter. I love it. Oh yeah. Did you say, Amy, are we doing that? You gonna be the VP? Oh man, I'm already losing enough hair as it is. What else are y'all saying? And this is a great conversation. We still got a bunch of y'all in here. Oh, we still got 1,000 people in here. We talking about OUIs and y'all chilling. Thank you to everyone who's in the building. Make sure y'all like the video. This is a great conversation. No, that would have happened the last trial then. Jurors have already said they were only hung on one charge. Yep, exactly. If they are hung on part 5, then they can try her on the whole second charge. Exactly. Yes. Shout out to Amy. Big difference between 21 and 49. Yo, yeah, Karen, get it together. Well, last time they said not guilty on the 2, but in the retrial, all were included again this time. That was the whole issue with the double jeopardy. Again, I understand it for myself, but I would not feel comfortable explaining it to you guys. So there's a lot of amazing attorneys out there. Shout out to Emily Baker, Melanie Little. That would be, we've got some amazing attorneys here. We've got the Honorable Attorney Kel Bell. When it comes to the double jeopardy and how that would be handled, I'd feel way more comfortable with them answering that question. And as to why it didn't happen the first trial, from what I understand was the jury did not realize that they could say, oh yes, we found her not guilty on this first charge. We found her not guilty on the third charge, which I don't know if the third charge was included the first time. So we're hung on this one charge. So that was the issue. I can't even say hung anymore without laughing. My husband got a DUI. Way high and only had one beer. We get to court with his lawyer and seems everybody got the same high number for the whole weekend. It was their equipment. Thank goodness for a good lawyer. You know, shout out to the lawyers. OUI wasn't included last time. Interesting. Yeah, I believe I heard that the defense wanted OUI included, which I think was a smart move. I think it's smart. You got to give, after all of this mess, after 2 trials, you got to give some type of win. It's just like a plea deal, but plea by trial, I guess. I don't know what you call it. Kara Hampton in here again with the 10 bomb. He says, I'm sorry, I'm rude. It's hump day. May we all have a great day on purpose. There it is, Kara. Thank you. May the jury get it right. Smile at someone today. You never know what a smile can do for someone. Amen to that. Kara, I love that. Amen. Yes, says Raunchy Dog, but the defense argued after the fact that they should have been able to break down the charges separately, and Bev said they waited too long to object. Dang. Sugar, alcohol, and sugar-free gum or candy can affect a breath test as well. I would never take a breath test. That's crazy. No. If an OUI is a crime, then why is there a legal limit? You're under the influence, right? Great question, Chris Easter. Let me see if I can get some more insight on that. Well, here's my interpretation of it. My interpretation is it's not the drinking and getting in the car that's an issue with the OUI. It's the drinking, and I quote, that your ability to operate the vehicle safely is impaired. And how is that determined? By a breathalyzer, by a field sobriety test, and by blood or urine test. But also there's a caveat here, because it said, where did it say somewhere? That if the officer sees something, obviously, if the officer sees something, if you're swerving across the road and say, hey, Chris, come on, dude. Is that a Bud Light over there? First of all, why are you drinking Bud Light? Secondly, dude, what's going on? So there's that factor too. So again, as who was saying that is too, was it Artsy or Artie? I don't know why I want to say Artsy. Was it Artie that was saying it was too broad? It's just the definition is very, 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 very broad. it seems like. Which is just, it seems like that's how the law is in general. We've got KC Travis is in the building with the 5 ball and says, I say yes to the verdict coming today. Coming today, every day. I'll be right at some point. I see what you're saying, Casey Travis. Hey, y'all, question. Who's waiting for the Kohlberger trial? Okay, so it seems like y'all are all on this Brian Kohlberger trial. Are we doing this, guys? Type a 1 in the chat if we're going to cover this Brian Kohlberger trial. Type a 2 if y'all are like, I don't know, maybe we'll find something else. 1 in the chat if you want to do it. 2 in the chat if we're going to keep it moving and find something else. Because that's the 11th time I've heard about Brian Kohlberger. So we might have to cover that. Let's see. Bev should have dropped the double jeopardy. I agree. Bev is crazy. They didn't know and they didn't ask the first time. They acquitted on 1 and 3 last time. Yep. Well, in their heads, they never signed the jury form. Oh, man. This justice system, this legal system, we're going to start calling it, is disgusting. Yes, giving juries splitting the baby verdict option. I thought it would be yesterday. I thought it would be Monday. I'm surprised that we're at today. I agree. I played an attorney at work for 20. Shout out to Vintage Galleria. That's super dope. Thank you for those of you who are out there playing the attorney. If Karen is innocent and found not guilty, what comes next? We've seen it happen before. It's not okay. What happens next is you say a prayer for her, and you use this as yet another example of, 1, while people should stay out of the system. 2, while you should be careful who you surround yourself with. And 3, is to make smart choices. Guys, believe it or not, alcohol is not necessary. Believe it or not, participating and acting a certain way and behaving a certain way and being involved in certain things, there's just a risk that comes with it. So you gotta, that's all we can do. And then you can get out and vote and get to know people who are trying to make positive changes to the system, because we've seen Karen Reeds getting locked up for a long time. It's sad, man. It's sad. That's why I stay on this side as much as I possibly can. And that's why I stay inside. You know what I mean? Shout out to Amy. The problem with them doing the OUI is she will slam her with the max and the sentence would have to be appealed. Yes. I don't think she does any jail time for that though. Even though she would get hit with the max, I don't think she's going to do any jail time. She shouldn't. Y'all are saying, yes, let's do it. 1. There's the Honorable Kel Bell. The Honorable Kel Bell is in here. Says yes to Kohlberger. Kel Bell, please, I have to hear your opinion on the OUI. We've been going back and forth about this OUI. We went over the amended verdict slip. Kel Bell, based on, just hear me out for a second. Based on how this is reading right here, for the OUI, we've got guilty of a lesser included offense, operating under the influence of liquor, operating a motor vehicle. We're going to check one or both. Was Karen Reed operating a motor vehicle under the influence of liquor and or operating a motor vehicle with a BAL of 0.08 or greater? Kel Bell, do you believe the evidence has shown that one of those things are true and that one of those things Karen Reed is guilty of? I have to know. We have to wait for Kel Bell's decision. This is going to be the deciding factor. The Honorable Kel Bell, we have to know. Has the Commonwealth proven beyond a reasonable doubt that Karen Reed was either 1, operating a motor vehicle under the influence, or 2, operating a motor vehicle with a blood alcohol level of 0.08 or greater? I have to know what you think. Amy says, add to that witness testimony that she was not intoxicated at the waterfall. I don't even know how to say a waterfall like that. The presence of multiple police officers who let her drive home. The test at the hospital was after she had been upset and drinking at home. There's zero evidence to convict her of DUI. Oh, here we go. The Honorable Kel Bell. This is the deciding factor. Here we go. Shout out to the Honorable Attorney. Kel Bell says, I think she admitted she was drinking. That's probably why they wanted to know if the interviews were evidence. I don't think they prove she had a BAL of 0.08 or greater. So, Kel Bell, if you're a jury member, if you're a juror, are you going to number 5 and are you checking off that yes, Karen Reed is guilty of operating a motor vehicle under the influence? Kel Bell, I have to know. We've been going back and forth about this for an hour. Peter's in here. Oh my goodness. Peter Ortiz is in the building. We've got a celebrity in here, guys. I cannot believe it. Peter is back. Oh man. Shout out to Peter Ortiz. Also, big shout out to my awesome, amazing Amy with the 5 bomb says, I'd be home. What did she say? Oh man, I lost it. Hold on. Amy says, I'd be home Googling how's long to fill out a verdict slip at this point. Dang. Dang. Peter Ortiz is in the building. Shout out to Peter. Where's Kel Bell at? Did Kel Bell respond? I have to know. We have to hear from one of our amazing community attorneys in here. Shout out to Peter. Don agrees with Kel Bell. I agree with the blood alcohol as well. The lab tech said, had they known that Karen was on MS medication, that would likely throw off the BAC levels and the blood work. Again, Brennan said he picked the timeline. It was the 12:30, 12:45 time. So we just throw the BAC out at this point. Her statements aren't proof though. It's evidence, not proof that she was over 0.08. We're off of that, Artie. We're talking about her operating a motor vehicle under the influence. She says, hey, I was wasted. Hey, I had shot. And then I got in the car and I drove John to 34 Fairview. That's evidence, guys. And AJ was trying to fight on that, saying, well, you know, just tell them they can weigh that as evidence, if at all. Kel Bell, where are you? I need your voice of reason, Kel Bell. We got, and she was driving fine at the time, and that's the bar. Alcoholics drive fine all the time while being absolutely plastered. I know some of them closely, so here we go. Kel Bell doing the attorney thing. The Honorable Attorney Kel Bell says, is the only element for 5 the fact that she drove after drinking? If so, unfortunately, yes. You guys don't want to listen to me. That's crazy. There should be something more than just driving after drinking. There is. It's an and or, Kel Bell. It's not crazy. I think what happened was the defense made a calculated move. I think it's a smart move because we see the jury sitting over there going back and forth like we have been for the past hour. So it's an and or, Kel Bell. So guilty of a lesser offense, operating under the influence of liquor. Stop. Operating under the influence of liquor. Stop there. Check one or both of the following. So again, was she A, operating a motor vehicle under the influence of liquor? You can stop there. Or was she B, operating a motor vehicle with a blood alcohol level of 0.08 or greater? Or was she C, all of the above? You get an option of one or both. So Kel Bell says, okay, with the and or, it's no. Oh, so Kel Bell says it's a no. Who served her? Did they testify? All I've heard is hearsay. I drove better. Y'all can't be saying this stuff on the internet. Oh my gosh. Proof of evidence of impairment at the time. Alcoholics carry a regular level in their system at all times. I think Karen Reed is one because she was always testing at a bar. I drove better drunk. Totaled 3 cars instead of 1. I can laugh because it was 40 years ago and 2 were parked. I lost the license for a year, got sober by the grace of God. Karen should get sober. Shout! I'm glad you turned the page there, Sassy. And Jesus. Hey man, we all have our what do they call them? We all have our things that we deal with. Okay, so Kel Bell, now I need some clarification from you. Because you're saying if it's an and or, then she's not going to be guilty of the lesser included offense. But do you believe, Kel Bell, do you believe that the evidence shows that she was guilty of operating a motor vehicle under the influence of liquor? Because I think we all agree, and let me know if you guys disagree. I think we can all agree that there's no legitimate evidence and nothing that shows beyond a reasonable doubt that her BAL at the time was 0.08 or greater. Indiscretions. There you go, Cynthia Harts. Thank you. I know Amy's putting the no comment because we were just talking about this. Amy says Karen is on medication for MS every day and her labs are going to be different. But that doesn't. Yeah, we're off. I want to leave this out. And we got to talk about operating under the influence of liquor. DG1 says there's no proof.
Right. And so what we have ultimately is that there is no evidence, none.
Judge Beverly Cannoni, the Honorable Judge Beverly Cannoni, said that the video clips of Karen in an interview saying that she was drinking and that she was driving are evidence, guys. I know I said honorable just to get on y'all's nerves. Those are evidence. So are you saying so? So what are you guys saying? I need to understand what you guys are saying about her operating a motor vehicle under the influence of liquor, because it seems pretty straightforward to me. Now we're talking about this one. Amy says, how can you convict her of OUI when no one pulled her over and tested her? The cop was in the passenger's side seat. Evidence of drinking, not drunk. You don't have to be drunk. You have to be under the influence. My guy Peter is back and he's ready to cook, Karen. What does he say? With the 10 bomb. My first true love was killed. Oh, man. Hold on a second. Oh, my goodness. So Peter's gonna feel the same way that I do about this driving under the influence. Peter says with the 10 bomb, my first true love was killed by a DUI offender 3 days before our wedding. Dang. I have no use for drunk drivers. He got 15 years. Wow. Peter, Oh, I'm so sorry. I can't imagine. Thank God I have not experienced that personally. I've known alcoholics and I've seen them and how they function and how they are. I've seen people who have decided to make stupid decisions and drive after they've been drinking. And to hear that you went through that and you had that person taken away from you is so sad, man. And I think there should be. I think that's how we should be. It's 2025. There's no excuse. Don't drink and don't drive. And thank Kelbell's on my side. Oh, here we go. Kelbell back at it. We've got the honorable attorney. See, I'm officially an attorney, y'all. Y'all don't want to listen to me. I tried to tell you guys this. The honorable attorney Kelbell says, don't her own words prove it? What? If I remember correctly, she said she drank and was the one driving. That is those, as Kelbell would like to say, those are facts and evidence. It is a fact, guys, in evidence that Karen Reed was operating a motor vehicle under the influence of liquor. I shouldn't even be having this conversation with y'all. To be real, Kelbell, we agree on that. The jury forum is absolute garbage. But the facts and evidence are the facts and evidence. And Karen Reed, for however much she got paid for it, sat in an interview and said, we have on video Karen Reed sitting there. All right, let's go. There's no doubt in my mind that Karen Reed was operating a motor vehicle sober at 12:30 a.m. Like her attorney said, that isn't evidence. Too bad it is evidence, Amy. Too bad. I'm with Peter. No use explaining drug driving. I'm not gonna. Nope. No. I've seen enough. I saw Karen Reed like, yeah, I was over there drinking, man. I drove John to the party. I see her at the bar. No. And this is where I'm with Kelbell on this one too. He says, I agree, it shouldn't be evidence, but it is. I think the OUI charge will be thrown out on appeal. I agree. That's where we agree. But what I think we all have to come to the conclusion on is what type of evidence you want to call it? I don't know. But there's a ton of evidence that shows Karen Reed was operating a motor vehicle under the influence of liquor. I don't see how you get away from that. But that's why we're on day 4 of deliberations, because of this conversation. But yes, I'm with you on this one, Kelbell. I think it's lame. I think this verdict slip is garbage. And yeah, it's terrible. Kelbell said the jury can get around this by using the 5 a.m. time. I think they should get around it by saying guilty. Just get it over with. Why are we going back and forth with this? Just say no on the BAL and yes on driving under the influence. Let's get out of here. Oh man, sorry, my husband was killed, but he was the drunk driver. He left me with my 3 boys. Oh man, we got to get off of this topic. Brenda, I'm sorry. It's not worth it, guys. Can we go ahead and ban alcohol? I'm taking all y'all's drinks away. I don't care. You know what? Y'all want to make me president? Amy's going to be VP. My first executive order as president is y'all's alcohol is gone. Ciroc, Henny, all of it banned. I don't care. That's my first act as president. Y'all have no more alcohol. ClassE would love prohibition. Bring it back. I'm bringing it back, y'all. Let me throw my criminal justice degree in the trash. Let me just join the Commonwealth side. Sorry, Amy. You've got two. Well, you've got one real attorney and one fake attorney, being me. The real attorney being Kel Bell. Amy says that's not the point. Morally, she was wrong and did it. But when you're going off of evidence, there is too much reasonable doubt. Reasonable doubt that she was drinking and driving. Oh boy. Oh boy. Oh boy. I'm not seeing it. If I call Amy and bring her up here, we're going to be on this topic for another hour. Amy doesn't want to be VP. You want to be president, Amy? You're not going to sign off on that executive order? I know Amy would sign. If I say Amy's going to back that executive order. ClassE, take alcohol and tobacco. That's cool. Moral versus legal. Sorry. Drink and walk or get an Uber is simple, or don't drink at all. Class, what do you say about the states with legalized marijuana? That's good. It is what it is. I say if you're going to legalize marijuana, then everybody who, I don't go down that route. I don't have a problem with marijuana. Amy says she'll back it up. Here we go. No reasonable doubt on if her levels were that high. No. I'm telling y'all, we're over the BAL conversation. We're talking about operating a motor vehicle under the influence. Yes, it did, Amy. Yeah, it came. You knew what you were saying. I don't drink anymore because I don't like how it makes me feel, but dang, ClassE, let people be. Nope. No. No. You can legally drink and drive, just can't be impaired. That's not what this says. Was she guilty of operating a motor vehicle under the influence of liquor? So I guess we're going back to the definition of under the influence. Kel Bell, if you're still in here, can you tell me what your definition of under the influence would be? Because from what I'm seeing, first you have to measure it to determine if someone's under the influence. But then you can also use determining factors like if a police officer sees you swerving in the road, and then you go and you pass the BAC, you pass the FTS, you pass the blood or urine test, and you say, oh yeah, I've been drinking, you pass all those tests, a police officer can still arrest you for OUI. From what I understand, I could be wrong. They're back in court. I don't see that they're back in court, guys. I'm looking at the feed right now. I don't see it. That was from this morning. Let me rewind. No. So we're still talking up in here. Yeah, Peter says she admitted to being drunk and driving. Yeah, Amy's gonna be the VP. She doesn't have a choice. Gee, you guys make me late for work every day. Sorry. Sorry, Sassy and Free. It's not drinking and driving, it's under the influence. Prove under the influence. I don't do DUIs, but you need to look at the relevant statute for the definition. Let me see if I can find it. Of under the influence. All right, I'm gonna try and find it, Kel Bell. We're working here. We're working. I'm officially a paralegal now, so give me a round of applause. Oh, Kel Bell's gonna love this. Guys, I'm a paralegal. It's official. Kel Bell, can you just say you fake hire me in the chat so I can put this on my resume? Here we go. Here we've got the statute here. We got the general laws, we've got the Massachusetts general laws, the MGL, chapter 90, section 24, the primary statute governing operating under the influence of OUI offenses. We finna learn y'all something today. But before I get into it, shout out to Keeping It Moving. New York says presidential tax in my life. Enjoy it while you can. Enjoy it while you can. Keep it moving, New York, because when I become president in 2028, y'all are done. Y'all are done. I don't even want to see even the mini bottles. They gone. I'm taking all y'all's out. I'm taking the wine. Italians are going to be furious all over the nation. Kel Bell said, "ClassE, we're hiring. I'll put in a good word." Yeah, show them. They've got the footage. They got the tape. Show them my tape, Kel Bell. I'm ready. Here we go. What the statute says about under the influence. While 9024 doesn't spell out a precise scientific definition of under the influence, courts have interpreted it to mean, here we go, a person under the influence or is considered under the influence if they have consumed enough alcohol or drugs to reduce their ability to operate a motor vehicle safely. So again, we're going back to the same thing we just went over. By impairing their judgment, alertness, coordination, or ability to respond. So here's what we have to look at. We have video of Karen admitting that she was drinking. She texted Brian Higgins that day. It was like, man, I'm about to, or she texted John, excuse me. It's like, I'm about to go out. It was 3 p.m. She was drinking. We have a video of Karen and John at the bar. She's taking shots. Do we think that Karen Reed, and I quote, consumed enough alcohol to reduce her ability to operate a motor vehicle safely? We're talking about reasonable doubt, guys. If you walk up to me and you say, hey, ClassE, we know you're going to be driving from your house to the office this morning. Say, okay, there's going to be you and 2 people on the road. All right, cool. The second person on the road with you is going to be someone who's drinking at 3 p.m. It's going to be someone who was just at a bar and they were shot. They took a sip out of somebody else's drink. Are you okay with that? Do you think they're going to have you? Do you believe beyond a reasonable doubt that they have a reduced ability to operate a motor vehicle safely based on you knowing those facts? I'm going to say, what? Can you take their license? They're going to be driving? No, I'm good. Please. I don't want to be on the road with that person. I can say with reasonable certainty that someone who has consumed that much alcohol would not be able, or let's not even say would not be able, would have a quote, reduced ability to operate a motor vehicle safely. You don't have to know. Vintage Galleria, do we think or do we know? We don't know that John O'Keefe was not hit by Karen Reed. We don't know that. But we believe beyond a reasonable doubt that she did not hit him. Guess what? I believe beyond a reasonable doubt that Karen Reed had a reduced ability to operate a motor vehicle safely. Sorry. Key legal interpretations. Massachusetts courts have repeatedly held that a driver need not be drunk just impaired to any degree by substances. We're done. I'm done on this conversation. The amount consumed is less important than whether it affected the person's ability to drive safely. Prosecutors do not need a BAC test to prove someone was under the influence. Observations and conduct can be enough. So you mean a video of the person saying that they did it and they were tipsy? What's the definition of tipsy, guys? You mean the video of someone behaving a certain way, downing a certain amount of drinks in the bar? That's allowed in as evidence? That could be enough? Yeah. Oh, and it gets even better. This is why Kel Bell is going to hire me this afternoon. I actually just saw an email come over from Kel Bell with a job offer because we have case law for you guys. I told you. I'm a paralegal. In the Commonwealth versus Connolly, the court clarified a person may be found to be under the influence of alcohol, even if he or she is not drunk, but has consumed enough alcohol to reduce their ability to operate a vehicle safely by diminishing their judgment, perception, and motor skills. That is Commonwealth versus Connolly. Y'all can look it up. 394 Mass, 169. And that was in 1985. There hasn't been a lot that's changed with people drinking and getting in the car since 1985. Other than Teslas, I guess. I'm done. But y'all are done. That's a great point. Kel Bell said we need to review her interviews that are in evidence. What exactly did she say? That's what the jury is working on right now. We had some amazing clips set up by Hank Brennan in the Commonwealth, and not guilty on all charges. Excuse me. This is the perfect holdout for a mistrial. Yeah, y'all see, we've been going on about this for an hour and a half. Her own BF, who is a Canton cop, let her drive. Well, he's dead, so there's that. I think if a police officer lets you rob a house, that doesn't make it legal. But I guess I see your point. You haven't proven diminished capabilities. Hey, Kel Bell. I want to address this. Because now we're getting into words and the meaning of words. And I'm going to look up Massachusetts law. But Kel Bell, if you're still here, I know you're busy. I want to know this. If you go and you have a bunch of drinks and you go and you get in your car and you sit there and you turn on your vehicle, or you sit there and you get in your car and you're fumbling around with the keys. You open the door and you turn on your car. Can you get charged with the OUI? I need to know this before I respond to Paua Eyes, who says you haven't proven diminished capabilities. Don already gave the answer. Don says yes. So Paua Eyes. Here's the problem. In that instance, you have all these drinks and you get in the car, you're fumbling around with the keys. You turn the car on. How have you proven diminished capabilities at that point? No. You weren't even driving the car. You started it, officer. I started it. You don't know if I would have made it home or if I would have been swerving around the road. I've been doing this for 40 years, officer. Leave me alone, man. I started the car. I got in. Let me go. Guys, it's time. It's time to find Karen Reed guilty of operating a motor vehicle under the influence of liquor. It's time. That's my final plea to the jury. I'm gonna let y'all have it. Let me see if they're back in court. Man, I was not planning on talking about OUI for an hour and a half today with y'all, but this has been amazing. Jose said, next topic. Even putting the keys in to listen to the radio is operating a vehicle. Yeah. All right, we're going to go back to Michael Proctor. Again, thank y'all for all the insight. This is absolutely amazing. Kel Bell said she's going to send me over an offer letter today. I cannot wait. That's it. I'm done with YouTube, y'all. I'm going to be a paralegal. We got Cynthia Hartz in here showing some love. With the 5 Bomb says, I would support you, but you would be impeached in a month. Just on prohibition? Dang, y'all are petty. Oh, man. For the record, I'm not a drinker. Shout out to Cynthia Hartz. I appreciate that. Y'all are amazing, man. I can't believe there's a thousand of y'all in here watching this back and forth. Don says, ClassE, in a case, there is a case, officer arrested a guy for that exact situation. It happens a lot more often than you think, Don. In that exact situation, it got thrown out because the guy had the bar's permission to sleep in the parking lot. Well, then that's tough too, because I know South Carolina, you can't sleep in a parking lot like that. It's illegal to even sleep in a parking lot. So I don't even know what was going on there. But if he did the right thing and he slept in his car, shout out and salute to him. I respect it. Lost my license for 6 months just for having a switch on. Spring Flowers knows what's up. Kel Bell, I need a job after I take the bar next year. Oh, shout out to Casey and congratulations. I have offers, but more is always better. Congratulations, Casey. And thank you for being here and giving your insight as well. All right, what we're going to do is, I haven't seen any updates from court yet. So we're going to go back to Michael Proctor. Y'all give me a second. We saw him getting cooked in the first trial, a little bit of a rewind from yesterday. Today, we're going to get back into it and see what AJ has to say to Proctor. Because again, I have not watched the first trial. So we're going to go ahead and get back into it. And I know a lot of y'all
based on the
haven't
evidence.
Give me 1 second, guys.
My office uncovered that day the one shoe discovered at the scene, the one shoe at the hospital, Mr. O'Keefe's injuries, the broken taillight pieces underneath the snow.
Super Proctor, I didn't ask for an explanation. I asked, did you, in your mind, have this case wrapped up? Was it cut and dry in your mind?
Yes.
Bird then writes, so the owner of the house was a woman. Sorry, was a woman cop that beat him, question mark, right?
Yes.
And then you wrote, that's what I initially thought after talking to Canton paramedics. Is that right?
Yes.
And then you said, then I saw the guy, correct?
Correct.
So what you meant by that, Trooper Proctor, was according to you, based on your conversations, your initial conversations with the paramedics, the first responders, you were under the impression that this was a beating death. He'd been beaten to death, correct?
The way it was given to me, sir, was
That's yes
for
or
medical.
No? That's yes or no?
He's going to answer the question. If you want
Go
to
ahead.
withdraw the question, you can.
No, go ahead.
We entered this investigation with an open mind. It was given to me as a medical situation. And when we saw Mr. O'Keefe's body at the hospital with Sergeant Buchanan and I, we saw his injuries and we were kind of working through how these injuries occurred.
As a matter of fact, both you and Sergeant Buchanan believed that he had suffered the injuries as a result of a physical altercation
Not Sergeant
based on
Buchanan.
information you received from the paramedics
Not
initially,
Yuri.
correct?
Initially, we didn't know what we had. We knew there was some significant injuries to Mr. O'Keefe. And we're still figuring out how those injuries occurred.
Well, you just testified. Initially, we didn't know what we had.
Right.
But 16 hours after the fact, you wrote the following sentence. That's what I initially thought after talking to Canton paramedics. Correct?
Correct.
So initially, you did think you knew what you had. A physical altercation leading to a death. Correct?
Correct.
So when you just said, initially we didn't know what we had, that wasn't quite true. You did at least have an idea of what you thought you had, correct?
Objection.
Sustained.
All right. You were aware, initially, that John O'Keefe had suffered a 2-inch laceration to the back of his head, correct?
Yes.
That resulted in a skull fracture, correct?
Correct.
He had a laceration over his right eye, small laceration just under the eyebrow, correct?
Yes.
Had a laceration on his nose. Is that right?
Correct.
He had patterned scratches on his right arm, abrasions, scratches, correct?
Yes.
And he had no injuries below the neck.
Not that I observed, sir.
Not a single broken bone, correct?
Not that I was aware of.
Not a single fracture, correct?
Not that I was aware of.
Not a single bruise below the neck, right?
Not that I observed.
Looks a lot like a physical altercation, doesn't it?
Objection.
Sustained.
Bird writes, Bear, let's focus, correct?
Yes.
Who's Bear?
That's another nickname I have.
0095 writes, what does she waffled him mean? And then Bird writes, what's the story, correct?
Correct.
And you wrote, she hit him with her car. Is that right?
Yes.
Have you ever seen, in your experience, have you ever seen a pedestrian who was hit by a 6,000-pound car with no bruises? Ever?
The pedestrian strikes I've seen have been at high speeds,
And that's
60
enough
plus.
A person out of his shoe, right?
60 plus miles per hour. So I can't recall right now off the top of my head as far as injuries in the past pedestrian strikes I've attended.
Okay. So someone, you indicated on Monday, under examination by Mr. Lally, you've seen a shoe missing,
Correct.
pedestrian strikes, correct?
Yes.
Those are high speed, extremely high speed incidents, correct?
Yes.
60 plus miles an hour, right?
I can't recall all the pedestrian strikes I've been to as far as the miles per hour the vehicle is traveling.
Trooper Proctor, let me ask you the question again. Have you ever, yes or no, have you ever, in your experience, seen a vehicle pedestrian incident in which the pedestrian has no bruises?
Objection.
Have you seen that?
I can't recall.
Okay, next question.
My goodness.
After you wrote, she hit him with her car, 5051 writes, oh Jesus, and Bird writes, okay, that's fucked up, correct?
Correct.
Nasty.
And then you wrote what?
Nasty work.
Intentional or not?
Intentional or not? Is that right?
Yes.
Your words.
Correct.
0095 then chimes in, gotcha. He was frozen in the driveway and she didn't see him? Question mark. Correct?
Correct.
And you wrote what?
That's another animal we won't be able to prove.
That's another animal we won't be able to prove.
Oh
correct?
my goodness. Dang, that should have been it right there. That should have been it. He said, we're not going to. The investigator said, yeah, we're not going to be able to prove that she did it. Yikes.
Trooper
No
Proctor,
wonder they
you
got
knew
rid
that
of
there
this
were going to
guy.
be things in this case,
Dang.
even 16 hours into this, that you just admitted you would have zero proof of, correct?
Objection.
Sustained. You can ask it differently.
Did you mean by that statement that this was one of several things that you knew we would not be able to prove?
That statement, that's another animal we won't be able to prove, references the intentional or not part.
You didn't
knew-
care at that point when you wrote that, you didn't care what you could or could not prove, did you?
Objection.
I'll allow it.
Isn't that what you meant?
No. I,
You had a narrative that you had developed, and you would pursue it no matter what the proof was. That's what you meant by that statement, correct?
Objection.
Sustained. You can ask it differently, Mr. Judge.
Did you mean by that, thank you, Your Honor, I didn't mean to step on your words. Did you mean by that statement that you were going to pursue this case no matter what the proof might be?
what I meant by that statement was if Miss Reed backed into Mr. O'Keefe intentionally or not.
Interestingly, though, that statement came on the heels of
This is
he was
so
frozen
messed
in the
up.
driveway and she didn't see him. And you wrote in response to that question, that's another animal we won't be able to prove. Correct?
Wow.
That's not what I was responding to. I was responding to the intentional or not part.
So you were responding to your own statement, according
Correct.
Okay. 0095 then writes, what's the name of the Canton cop living in Canton? The other one involved. Correct?
Yes.
In other words, that person was asking, tell me the name of the homeowner. Isn't that right?
Yes.
The guy that's the cop, right?
Correct.
And you ignored that question for a second time. Is that right?
Yes.
As a matter of fact, not one time, not once in this entire group chat did you disclose the name Brian Albert, did you?
I don't believe so, no.
You were actively trying to hide Brian Albert's name, at least from this conversation.
Appreciate you, Peter.
I'll allow it. Is that what you were trying to do?
Absolutely not.
But you had no problem sharing John O'Keefe's name with your buddies from high school, right?
Correct.
And you had no problem sharing Karen Reed's name with your buddies from high school, correct?
I don't believe I named the defendant.
Not yet, you didn't. Later in the chat.
Okay, correct.
5051 then writes, the BPD have any jurisdiction here because it was their own? Question mark. Is that right?
Yes.
And a few texts later, if you look down a few texts, at about 11 o'clock, you see a text that starts, nah, cat.
I do so, yes.
You responded, quote, nah, N-A-H, nah, cat, K-A-T-T. It's the total opposite. They have to recuse themselves. Same with Canton. Correct?
That text ends as they have to recuse themselves.
Come on.
You
dude.
then text back, I'm sorry, can I have a moment?
Yes.
Flip the next page.
I see where you're at, sir.
How did you end that text?
Same with Canton.
Meaning Canton has to recuse itself also, correct?
That was my understanding.
So by 11 p.m. on January 29th, 2022, there was no question in your mind, Trooper Proctor, that the Canton Police Department was recused from this investigation in all particulars, correct?
That they had taken a step back from participating, yes.
Right. Well, there's one way to put it. They've taken a step back from participating. Another way to put it is they recused themselves completely, correct?
Correct.
They were not going to be, at least in your mind, they were not to be involved in any way, just like Boston PD was not to be involved in any way. Is that right?
Objection.
Is that what you were thinking?
It was my understanding they were not going to be involved.
Now, if we could turn to page 2537. 5051 writes, but I assume you guys are out to make it cut and dry since it involves cops, correct?
Yes.
Oh, that's disgusting,
And Bird writes,
man. Damn.
something stinks, correct?
Correct.
And then Trooper Proctor, you responded, yeah, but there will be some serious charges brought on the girl. Isn't that right?
That's right.
So in that text exchange, you were saying, yeah, we're out to make it cut and dry, correct?
No.
You didn't write,
This is so.
yeah, we're going to
so
follow the
gross.
evidence wherever it takes us. You didn't, did you?
I did not write that.
You didn't write, yeah, we're going to make sure that we investigate this thing fully and thoroughly before making any decisions. You didn't say that, did you?
I did not.
You wrote, yeah, but there will be some serious charges brought on the girl. Isn't that right?
Correct.
And the reason you wrote that is because you knew, as the text above it says, this has to be cut and dry because it involves cops, right?
Objection.
I'm going to allow that. Is that
Yeah.
the reason you wrote it?
No, Your Honor.
And then you indicated, we're going to put serious charges on the girl. Who did you mean by the girl, by the way?
The
Can't believe
defendant.
They called this guy.
Karen Reed?
Yes, sir.
What
So
a
the way
clown.
that you were going to make it cut and dry, pretty simple. Just pin it on the girl, right?
Objection.
Is that right?
Absolutely not. Follow the facts and the evidence from that day on the 29th, and everything led to Miss Reed hitting Mr. O'Keefe with her vehicle.
But that wasn't the question that you were answering, was it? We're going to follow the evidence and make sure we do this thoroughly. The question you were answering was, I assume you guys,
Yeah,
you,
AJ does look different.
Trooper Proctor, and your team are going to, quote, make it cut and dry since it involves cops, meaning Brian Albert, correct?
Incorrect. Doesn't matter to me if the homeowner's a cop, if the victim's a police officer. Myself and everyone in my office investigated this case that Saturday, had an overwhelming amount of evidence that Miss Reed struck Mr. O'Keefe. So it didn't matter to us what their occupation was.
We'll see. Let's keep reading, shall we? 5051, a little further down, says, gotta be, I could only imagine what internal affairs at BPD are trying to get out there. Correct?
Correct.
Meaning, this person, 5051, was opining, at least in your mind, you interpreted that as being Boston police are going to have a lot to answer for, given the fact that another Boston police officer was found dead on that officer's lawn. Correct?
Objection.
What were you thinking?
Can't speak to the mindset to that comment. I wasn't sure how to interpret that one.
All right, next question, Mr. Jackson.
Then 5051 changes gears. And he writes, she hot at least? Correct?
Yes.
And what was your response to that?
From all accounts, he didn't do a thing wrong. She's a whack job cunt.
Jesus.
From all accounts, he didn't do a thing wrong. She's a whack job cunt. That's what you wrote, correct?
Correct.
16 hours into this investigation,
Yes.
into
They
your
had it
objective
out for
and
her.
unbiased,
Out for her from the
thorough
beginning.
investigation, correct?
Correct.
And Yuri said he conducted this investigation with integrity.
Stop the cap.
With the utmost of integrity. Disgusting.
But sir, you didn't have all accounts, did you?
What I meant by that was
Did you or did you not have all accounts in your investigation?
the accounts we had was Miss Reed struck Mr. O'Keefe with her vehicle, discovered taillight pieces at the scene. Those are the accounts we had.
The accounts
And then
you
some.
had, I'm sorry, go ahead.
I'm sorry, go ahead.
The accounts you had, Trooper Proctor, were from two people named McCabe and one named Albert, who happened to be the homeowner and a Boston cop. Those are the accounts from percipient witnesses that you had, correct?
There was another additional witness that we had, investigators had interviewed, Miss Roberts as well.
And from all accounts, he didn't do a thing wrong. That was your decision 16 hours into the investigation, correct?
Yes.
And the other decision that you made and the other determination you came to was my client, Karen Reed, was a whack job cunt, right?
Yes.
Yikes.
What else did you say in response to she's
morning,
hot
Mr.
at
Brown.
least? Or she hot at least, question mark.
So following that text, I responded, yeah, she's a babe. Weird Fall River accent, though. No ass.
Yeah, she's a babe. Who's the she?
Miss Reed.
Weird Fall River accent, though. You talking about her, the way she talks?
The accent.
Jeez, man.
And no ass. Now you're talking about her body, her physique, correct?
Yes.
You think that's appropriate?
Absolutely not.
Guys, I'm immature. I'm
Then Bird
sorry.
chimes
I'll
in
grow up one day.
with a little comedy.
That gets
Not
me every
newsworthy
time.
then, correct?
Oh, I'm sorry,
Correct.
Karen.
In other
I'm
words,
Karen, I'm sorry.
well, if she didn't have an ass, nothing to see here, correct?
Objection.
Listen, Karen's never coming to the channel. I laugh at that every time. I'm sorry, Karen. No, Meredith, I'm never growing up. Never.
Sustain.
I can't. I'll never grow up.
And then 5051
Sorry,
says,
Karen, I'm sorry.
oh, she's skating, right?
It's terrible.
Correct.
Absolutely horrible.
And what did you write after that?
My response was zero chance she skated.
Look at Karen right there. Listen to all
And then
that.
what
She's
did you
like,
write?
She's fucked.
Zero chance she skates. She's fucked, right?
Correct.
You decided on the 29th of January, 17 hours into this investigation, you decided individually, Trooper Proctor, you're not only going to put it on the girl, you decided you're going to make sure this is cut and dried, and the way you're going to do it is to make sure that she's fucked.
no verdict.
That's
yet.
what you were saying.
Objection.
All right, so that's sustained. You can, the content's fine. You have to ask it differently.
I hate that they curse this much in court.
17
Like, I get
hours
they're
into this
just
investigation,
reading it, but
Trooper
dang.
Proctor, you made the decision that you were going to put it on Miss Reed, didn't you? Put the case on Miss Reed. She was going to catch the case, correct?
No, absolutely not.
What did you mean then when you said she's fucked?
After the day's investigation with multiple troopers conducting multiple tasks and a debriefing at Canton PD amongst detectives in my office, we went through the overwhelming amount of evidence against Miss Reed that she struck Mr. O'Keefe with her vehicle. That's what I meant by that comment.
That quickly? Yeah,
What you
me
meant
too,
by
Sun
that
Life. I
comment,
can't
Trooper
take it.
Proctor, was you were going to make sure because 5051 had said she's going to skate. She's skating. When you said zero chance she skates, she's fucked. What you meant was, I'm going to make sure, I am going to make sure Ms. Reed doesn't skate. She's fucked. That's what you meant, isn't it?
Objection.
Overrule. What?
And then Bird decides to chime in. Good, no ass bitch, right?
Yes, that's what he wrote.
And how did you respond to Bird saying, good, no ass bitch?
I laughed.
Thought that was funny, did you? Trooper Proctor? Thought that was funny?
It was unprofessional of me. That's something I shouldn't have done.
Well, I think we all know it was unprofessional. It was a lot of things. I'm asking
Yep.
you, did you think it was funny?
No, according to my response at the time, apparently.
Then you sent a picture. Just to
Oh,
add-
man, this is tough. Y'all see Mr. Reed back there hearing a dude talk about his daughter like that? Oh, I'd be, yo. Dang
No,
it.
according to my response at the time,
Two guys.
apparently.
Yikes.
Then you sent a picture just to add to it, to pile on, of Miss Reed being arrested, correct?
I don't.
Aussie, Aussie, Aussie.
Not sure if that came from me, sir.
Let's skip to 2543. Are you there, Trooper Proctor?
Yes.
The date is now February 2nd, 2022. And a person by the name of
There
Doc
it is.
writes, "Is that chick a smoke?" Correct?
Correct.
Who's the chick?
Misread.
And you write E-H, right?
Yes.
And then you write nutbag, as Chief would say, correct?
Correct.
Who's Chief?
A friend of mine.
And then you write what?
She's got a leaky balloon knot.
Trooper Proctor, explain to the jurors what a balloon knot is.
Your, essentially, I guess, your rectum area.
Your anus?
Yes.
That's what you were referring to about Miss Reed?
She's looking at her dad. Like,
Yes.
you hear this?
And you were making fun of her because you
Dang.
believed at that time that it leaked? That's how you were treating Miss Reed? Yes or no?
Yes.
And then you followed that up just to make sure you cleared up any
Look at
mistake
Yannetti.
about.
Look at Yannetti shaking his head. They already said that they hated this guy. He said, "Man, come on, dude. Look at his face. He looks like he wants to knock him out." Yeah, that's crazy, man. I mean, saying she has talking about a medical condition. Jesus, Amy, look at
That's what you were referring to about Miss Reed?
Yannetti's like, yo, come
Yes.
over here.
And you were making fun of her because you believed at that time that it leaked?
Look at his face.
That's how
He's
you were treating Miss
pissed.
Reed? Yes or no?
Yes.
It's disgusting, man.
And then you followed that up just to make sure you cleared up any mistake about what you meant with leaks poo, correct?
Objection.
All right, so I'm going to strike that. You could get this in, but do it the right way, Mr. Jackson.
You followed that up with the phrase leaks poo, didn't you?
I did.
Again, another reference to Miss Reed's medical issues and medical conditions, correct?
Correct.
Specifically focused on her anus, correct?
In reference, yes.
Were you aware at the time that you wrote this that Miss Reed had suffered a colectomy surgery, very serious surgery?
I was not, sir, no.
Were you aware that she had had 10 surgeries in 18 months, several years prior? 10.
I was not aware of that.
Were you
You didn't
aware that she
care.
had serious medical issues, gastrointestinal medical
I'm
issues
sorry, go fake yourself.
that she suffered with, she was a victim of for years? Did you know that?
Objection.
Sustained.
But you decided that you were going to take another shot at her and talk about her anatomy.
1 second, sir. I'm sorry. All set.
I'm sorry. Christine. You decided that you were going to take another shot at her and talk about her anatomy as a balloon knot, correct?
Objection.
Sustained.
At this point, Trooper Proctor, Miss Reed was just reduced to a
Disgusting.
punchline to you, wasn't she?
Objection.
Sustained.
Well, you weren't done yet. This chat doesn't end yet, does it?
No, sir.
Let's skip to 2543. On the same date, February 2nd, 2022, about 4:15 p.m., a person by the name of Whitey wrote, "What are you guzzling on?" Correct?
Yes.
And you wrote, "Nothing, writing a warrant." Is that right?
Correct.
why do you then share some sort of a video, correct?
Yes.
Do you remember that video being of the 1980s band Warrant?
I don't recall the video he sent.
0095 laughed
It's truly disgraceful.
and then wrote, wait, why does her asshole leak? Correct?
Yes, that's what he wrote.
And then what did Doc write in response to that?
Objection, Your Honor.
The objection sustained. I'll see it. Sidebar, take that down, please.
Yeah, Judge Bev heard enough at that point. No, disgrace this POS trooper or whatever. I don't know. Make him be accountable for what he did. It's disgusting, man. Like, I think this is, again, we mentioned this so many times during the YSL trial. This is just what we're hearing and seeing because it's been brought into the court as evidence. Think of what they're saying on a regular basis. And I mean, I don't want to. It's sad.
Without
that-
reference to-
Take that down.
Without reference to the specifics of what was.
I'm going to see counsel at sidebar.
Sure.
Again? Dang.
Fix of the word. Trooper Proctor, without getting to the specifics of the words used in the following, in the next exchange that you're looking at, it's fair to say that your high school buddies then continue to discuss Ms. Reed's medical issues, correct?
Objection.
That's sustained. Come on, Mr. Jackson. That isn't what you said you'd ask. Go ahead and ask the question you said you'd ask.
Was there a continued discussion that finished on this subject matter?
Yes.
Nasty.
On Monday, you indicated that your conduct in this case, and specifically your conduct as reflected in these messages, how did you put it? It did not affect the integrity of the investigation, of your investigation, correct? That's what you
Correct.
said to the jurors.
Correct.
Do you know what the definition of integrity is?
Doing the right thing when no one's looking.
Yeah.
It means the quality of being honest and having strong moral principles, correct?
Objection.
Sustained.
Do you believe that integrity means being honest and having strong moral principles?
I believe that's part of it as well.
Do you stand by that testimony that you were showing strong moral principles in this
No.
investigation? Sir?
In the investigation part, absolutely. Through these text messages, absolutely not. They were juvenile and regrettable.
They were about the investigation,
When
sir.
you say they're juvenile and regrettable, it sounds like you're almost apologizing to the jury for your conduct. Is that what you're doing?
For those text,
Objection, Your Honor.
Sustained.
Trooper Proctor, have you ever apologized to Miss Reed?
Objection.
Sustained.
That's fair.
As the lead investigator in this case, you were tasked with the responsibility of making sure that the investigation remained free of any conflicts of interest. That's part of your job, correct?
correct.
Throughout the pendency of this investigation and this case, you've denied having any conflict of interest in this case. Isn't that right?
Correct.
In fact, a couple of months ago in February of 2024, you testified in a different proceeding. Is that right?
Yes.
And you testified under oath in that proceeding on February 1st that you did not know any members of the Albert
Trooper Paul,
family
might have to
or
get to him.
McCabe family, correct?
Certain members of the Albert family I did not know. I know Chris and Julie and Colin. I don't know the McCabes.
That wasn't my question. Did you testify? Let's take them one at a time. Did you testify under oath, same oath you took here today, in a former proceeding in February of 2024, that you did not know and did not have any relationship with members of the Albert and McCabe families? Did you?
I haven't had a chance to review those minutes. I've only had one opportunity to, and that was a couple months ago. So I would want to review those minutes in order to answer that accurately.
You can't remember how you testified, whether or not you knew or had relationships with the Alberts and McCabes?
Objection.
Sustained.
As you sit here right now, you need to refresh your recollection. You can't remember what you said?
Objection.
Do you remember what you said?
During that proceeding, no.
Would it refresh your recollection if you took a look at those grand jury minutes?
Yes.
What page, Mr. Jackson?
This is page
This guy.
01563.
I don't think he should have been the only one that got fired either.
If I may have just a moment, Your Honor.
Yes.
Oh, shout out to Dottie. Oh.
May I approach?
Yes.
If you'd review that and look up when you're finished.
Oh, there she is. Come on, Trooper Proctor, you can read. You know what you said. You're a bum.
Now, Your Honor.
Okay.
Would that refresh your recollection about a question and answer that you had, or a series of questions and answers that you had while you were testifying under oath in that other proceeding?
Yes, sir.
Objection. May we approach?
Yes.
I'm unclear what this previous FBI investigation actually was, or if it was concluded. They were investigating corruption in that county. Was it unrelated to murder? That's a good question. I am not sure about that. Yeah, Yuri.
Yes.
Thank you. You were asked the question,
Discussing.
quote, did you communicate with First Assistant DA Beeland that you did not know and had no relationship with the Albert and McCabe families? And you answered, quote, to the best of my recollection, the same conversation took place with everyone I talked to about this, because it's the same answer. It's the facts that I shared with everyone. Question, meaning you told First Assistant Beeland that you didn't know, didn't have a relationships with
Objection, Your Honor.
members of the Albert and McCabe families. Answer, correct.
Yes, that's correct.
So your question is whether he said this?
Correct. Whether that's his testimony. Do you recall that?
Yes.
And that's your testimony that you, in fact, told members of the DA's office that you did not know and did not have a relationship with the Alberts or McCabes. Is that right?
I did not know the McCabes. I don't know most of the Alberts, and I have little to no relationship with Chris and Julie. So that's what I meant by that answer.
Well, the question wasn't, did you know most of the Alberts? The question was, did you have a relationship with, or did you know the Alberts? And your answer was, no.
No, I don't have a relationship with the Alberts.
Or know them.
I don't know the McCabes. I don't have a relationship with the Alberts.
So you do
You
know
asked-
the Alberts, correct?
I know some of them, Julie and Chris.
And Colin, correct?
Correct, and Colin.
And you knew the Alberts when you gave this testimony in February of 2024. Is that right?
Yeah, they asked if there was any relationships.
And let's try this again. Meaning you told First Assistant Beeland that you didn't know, didn't have relationships with members of the Alberts and members of the Albert and McCabe families. Answer, correct. Was that ambiguous in your mind?
The way I interpreted relationships was basically being like friends or, communications, frequent communications. That's how I interpreted
Well, that might have been a
relationships.
good time to pipe up and say, well, I know Chris and I know Julie and I know Colin, correct?
Objection.
Sustained.
That might have been a good time to answer the question, I know these three individuals from the Albert family, right?
Objection.
Sustained.
But your answer was one word, correct, right?
Yes.
You further testified that you never have gone to any supervisor at Massachusetts State Police to disclose even a potential conflict of interest in this case that you might have, correct?
Correct.
And you indicated the needs never come up. Is that right?
Correct.
You also told ADA Lally that you, quote, did not have relationships or know members of the Albert or McCabe families, correct?
Correct.
And that's just not true, is it? You do know members of the Albert family. Isn't that right?
It's different from having a relationship with people.
But what about part of the question, did not have relationships or know members of the Albert or McCabe families? How about that part of the question?
Well, that's lumped in with the McCabes. I don't know the McCabe family, sir.
I see. So what you did, Trooper Proctor, is you dissected the sentence, and where relationships are concerned, you ignored that in terms of the Alberts because you don't have relationships. Where no is concerned, you link that to the McCabes because you don't know the McCabes. That's what you did?
No.
Objection.
So it's sustained. You can ask it. You can break it down, Mr. Jackson.
Not sure I can. I'll ask it a different way. How about if I just ask it this way? That was a lie, wasn't it?
No, absolutely not.
You stand by that testimony?
Yes.
That you
Come
don't
on,
know
dude.
at the time that you testified, that you didn't know the Alberts or any members of the Albert family?
They don't have relationships with them.
Okay. My question is, you keep going back to relationships. I'm asking you, did you testify that you didn't know them?
Objection.
I'll let him have it. Do you understand the question, Trooper?
He didn't answer the
And it
question.
was Chris, Julie, and Colin.
So if you were to say, I don't know any members of the Albert family, that would have been a lie, correct?
Objection.
Sustained.
Your
Why is
Your
this
Honor,
a-
this is the point at which I intend to turn to tab 3, and I believe we need to approach.
Okay. Jurors, feel free to stand.
I don't know why that was sustained. If you lied, you lied. Must have been asked.
Yeah, just a moment, Your Honor.
Yes.
Asked and answered.
Trooper Proctor, you've indicated that your sister is one of your best friends, maybe your best friend.
Yes.
Courtney Proctor, that's her
That's
name?
nice.
Courtney
Correct.
Proctor. Elberg?
That, I'm sorry?
Her last name?
Elberg.
Elberg, with an L. And you're aware that she is also very, very good friends with Jillian Daniels, Julie Albert.
Correct.
Are you aware of any circumstance in which any of the Alberts have been over to your parents' house?
Yes.
Have you ever been over at your parents' house when any of the Alberts have been at your parents' house?
Yes.
Those Alberts include Chris Albert, Julie Albert, Colin Albert, correct?
Correct.
Come on, man.
As a matter of fact, you were on or around January 29th, 2022, you were close enough friends with Julie Albert that she had your personal cell phone in her cell phone, correct? And vice versa.
I wouldn't classify us as close friends at all.
Okay, let me get back to my question. Did you have her cell phone in your phone, and did she have yours?
I can't recall if I believe I had her stored in my phone.
Tab 4.
Wow.
All right. If you would turn to tab 4,
And what was this marked for ID?
this was,
Or tell me the numbers at the bottom.
I've got the sheet right here. I've got a cheat sheet. Tab 4 is triple B,
Okay.
as in Bravo. And Your Honor, for the court, I'm looking at page 2625. You have that in front of you, sir?
Yes, sir.
Do you recognize the participants in this chat?
I do.
The number ending in 5374, you recognize that as being from Julie Albert?
Based off the content of the message, yeah, I recognize this text message from Julie.
And she texts, "This is the weekend I've been waiting for. Michael, please send ski videos if CP doesn't share with me," with a laughing face, correct?
Correct.
Sounds like friends to me.
That text was sent on February 24th, 2022, wasn't it?
Yes.
That was less than a month after Mr. O'Keefe's death, isn't that right?
Correct.
And less than a month after you had been assigned to the investigation in which Julie Albert was a witness, correct?
Correct.
And her husband, Chris Albert, was a witness, correct?
Correct.
And her son, you knew, Colin, was involved as well, correct?
Yes.
Who is CP in that text message?
It's a nickname I have for my sister.
Courtney Proctor, correct?
Correct.
Your Honor, if I may have just a moment.
Okay.
Zoom tight. Can we move to Trooper Proctor to tab 5, please? That's triple C as in Charlie. Do you have that in front of you, sir?
Yes.
And this would be page 2664. If you return to that page, please.
Okay.
Trooper Proctor, on January 19th, 2022, 10 days before Mr. O'Keefe's death, you were texting with your sister about whether Julie Albert might be available to babysit for your own son, correct?
Yeah.
Yes.
Yeah. Proctor.
So in fact, your relationship with the Alberts was close enough that you would consider leaving your own child in the hands of Julie Albert as a babysitter, as a caregiver for your toddler,
This guy's
correct?
an insane liar.
I wouldn't say close enough. I've hired babysitters that
Look at you, Nettie.
I vet out, but I don't know.
But Julie
This
Albert
guy.
was among them, correct?
Yes, she was an option to watch my child.
And then you personally interviewed Julie Albert and Chris Albert in this case on February 10th, 2022.
Sergeant Buchanan and I did, yes.
And you didn't mention a thing about your relationship with Julie Albert, Chris Albert, or Colin Albert in any report that you ever drafted in this case, did you?
I did not.
Not one word, correct?
No, sir.
You interviewed Julie and Chris Albert at about 5:30 p.m. on the 10th of February, isn't that right?
Yes.
Did either of them, Julie or Chris Albert, mention that their son Colin Albert had been at 34 Fairview Road on the night in question, January 29th?
I'd have to reread the report to refresh my memory on their statements.
Well, let me ask it a different way, if I may have just a moment.
Yes.
You wrote a report on October 12th, 2022, correct?
For which,
Concerning your interview with,
Why don't you show it to him?
I may have the wrong report. You don't have to worry about it. Do you recall, Trooper Proctor, ever mentioning that whether or not Julie and Chris mentioned to you that their son had been at 34 Fairview on January 29th? Do you recall that as you sit here?
to the best of my recollection, no.
It was a very short interview with Julie and Chris, was it not?
It was typical length for the information they had to offer.
So you started the interview about 5:30 p.m. It must have been relatively short because you received a phone call by 6:17 from Julie Albert herself, correct?
I don't have the call detail record in front of me, but okay, yes.
Let's look at tab 6, please. Oh, it may not be in your book.
It's not, sir.
Okay, fair enough.
This guy, it's a terrible dude. Let me see if we have any updates yet. Still no updates, guys.
You
Looks like
indicated
they
that
might be at
you might need
lunch.
to look at a phone record or a phone log to determine whether or not that call was made and what time it was made, correct?
If you have that,
May I
please.
approach you on?
Yes.
Thank you.
There's a highlighted portion, Trooper Proctor. Just focus your attention on that and let me know if that refreshes your recollection.
It does, sir. Thank you.
May I approach?
Yes.
You received after your interview, you received a phone call from Julie Albert about 6:17, about 45 minutes after you began the interview and then left, correct?
Yes.
6:21, you called her back and you spoke for 3 minutes and 58 seconds. Is that right?
Yes.
Did you discuss the interview?
I don't recall the content of that conversation.
And of course, you never memorialized that in any report, did you? The fact that you had a subsequent phone call with Julie Albert on your personal cell phone.
I did not.
Let's turn to tab 5 one more time. And if you could turn to page 2677. Trooper Proctor, after your interview with Julie Albert, your sister, Courtney, texted you, "How did it go at Julie's? She was so nervous." You recall that?
Yes.
In fact, you responded to that with a ha, 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 ha. 4 ha's, right? And then why, question mark, correct?
Correct.
Then you responded, "It was fine, just a quick convo," correct?
Yes.
You were literally reporting back to your sister about the progress of your investigation in a homicide investigation, weren't you?
Objection.
Sustained. You can ask it differently.
Were
They
you
got this guy
reporting
fired.
your progress to your sister about your investigation?
Objection.
Sustained.
They really
Your
got
Honor,
this
may we
guy
approach?
fired.
Okay.
Yo, he said you were over here telling your sister what was going on in the active investigation, you clown.
Treated like
Good grief.
reporting your
Here we go. What a joke, man.
May I?
Yes.
Thank you. Were you reporting your progress of your investigation back to your sister, Courtney Proctor?
No, absolutely not.
But you did say that the conversation, the formal interview went fine. It was just a quick convo, correct?
In response to my sister indicating Julie was nervous, that's why I told her it was fine.
Trooper Proctor, Julie and Chris Albert were not actually treated like witnesses in a murder investigation. They were treated more like friends. Wouldn't you agree?
Objection.
Is that true?
Absolutely not.
We've established that you're very close with your sister, Courtney, correct?
Correct.
You provided your sister with updates on important advancements during the course of your investigation into this case. Did you not periodically?
I made her aware of newsworthy stuff.
That started as early as January 29th, 2022. Isn't that right?
Don't have the exact date or content.
Well, the day of the incident. You began letting her know that you were involved, that you had been assigned, what the status was,
Yes.
the nature of the case, the fact
Correct.
that it was a homicide, correct?
Yes.
Matter of fact, you discussed who the players were, who the people were that were involved. Isn't that right?
I just mentioned Julie and Chris were out earlier in the evening.
So you mentioned the Alberts, correct?
Julie and Chris, yes.
You also mentioned the McCabe's too, didn't you? At some point.
Yes.
Yeah. At 2668, Your Honor, that's the page that I'm referring to. Okay. We don't need to show this at this point. You write homicide, correct?
So I said 2668.
Correct. If I have my page number correct.
You're on the right page, Mr. Jackson.
Thank you.
Okay, go ahead, sir.
You wrote the word homicide. Is that right?
Yes.
You were describing to your sister the nature of the case that you are now assigned. Is that right?
Correct.
She wrote the Canton thing is a homicide, and you wrote don't say
This is
a word to
insane.
anyone. Correct?
Correct.
And then she wrote, of course not. Isn't that right?
Yes.
And then you wrote what?
In the very least, it's suspicious.
In the very least, it's suspicious.
He
Correct?
did this over
Correct.
text
So
messages.
at that
What a
time, at least at
dummy.
the time that you wrote that text on the 29th at 3:05 in the afternoon, you believed that the case was suspicious, right?
It was before we found significant pieces of evidence.
So you believed that it was suspicious that it may involve the Alberts, right?
Absolutely not.
They had no choice but to fire this guy.
She then writes, this is your livelihood, didn't she?
She did.
Meaning this kind of case could make or it could break your career, right?
Objection.
Sustained.
She then wrote, I would never mess with that. Is that right?
Yes.
Your sister, Trooper Proctor, was warning you that you shouldn't be investigating a case in which close friends or family members were involved.
Objection.
Sustained.
Did you take her text? This is your livelihood. I would never mess with that, as a warning from her that you shouldn't be investigating a case that involved close friends.
Objection.
I'll allow it.
Absolutely not. That was in response to don't say a word to anyone. And that was how I interpreted this is your livelihood. I would never mess with that.
A couple of minutes later, 3:07 on January 29th, you told your
He
sister,
said, don't tell.
quote, Julie and Chris were at the bar with the victim and girlfriend.
The bar.
Got to interview them. Is that right?
Yes.
So you were telling Courtney, your sister, updates on what your investigation advancements were, correct? Who
Just
you're
that
gonna
part.
Interview, why you're going to interview him.
Yes.
She wrote, "You got to be kidding me," correct?
Correct.
Did you take that as, "You got to be kidding me, the Alberts are involved"?
No, absolutely not.
What's up, Trina?
And then you wrote, "It's not a big deal," correct?
Correct.
And then she wrote, "I bet I know the person." Sounds like it is, meaning it is a big deal, right?
Yeah, I'm not sure what she meant with those messages there.
But she did write, "I bet I know the person," didn't she?
She did write that, yes.
And you know she's very close with the Alberts, correct?
And she's close with Julie and Chris.
You then wrote, "No, I meant," or you wrote "not." I think you meant "no." "I meant that they were at the bar with them," correct?
Yes.
She writes, "Yeah, I got that part." And then she continues on, "But I know a lot of their friends," correct?
Yes.
Did you see a problem in this exchange?
Nothing jumped out at me.
Your sister's literally explaining that your family friends are suspects or possible suspects in a murder investigation that you're in charge of. Correct?
Objection.
Sustained.
On January 30th, 2022 at 9:13 in the morning, your sister texted you again, quote, "Jesus Christ, the party was at one of the Alberts," correct?
Yes.
And you two were discussing the fact
It's
that,
sad, isn't it?
to put it in her
Amy said,
words,
"This guy's
Jesus
disgusting.
Christ,
I can't believe he's a cop."
these are our friends, right?
Objection.
Sustained.
How did you take her Jesus Christ, the party was at one of the Alberts with 2 exclamation points? How did you take that?
That's her. The way I'm interpreting my sister's text messages was that surprised and shocked that this is where Mr. O'Keefe was found on the front lawn of that residence.
Could it be, Jesus Christ, we know these people?
Again, that's how I read that message.
You don't deny, Trooper Proctor, that you were routinely disclosing to your sister pretty intimate details about the investigation, correct?
I wouldn't say intimate. I'd say newsworthy stuff or just generic, nothing
Well,
too specific.
newsworthy, would you have gone to the news at this point in the investigation? Would you have gone to the news and said, "Julie and Chris were at the bar. I got to go interview them"?
Objection.
I'll allow that. Is that what you do, Trooper?
No, I would not do that, sir.
So it was not newsworthy. These were details, internal details about the investigation, weren't they?
Yes,
And you were sharing them with your sister, Courtney Proctor, correct?
correct.
And Courtney Proctor's best friend is Jillian Daniels, and one of her closest friends is Julie Albert, right?
Correct.
Then on February 1st, 2022, your sister texts you that she's actually meeting with Julie Albert, didn't she?
Yes,
And that was before you ever interviewed Julie, correct?
yes,
So it appears that Courtney was providing information to Julie of some sort before you were able to actually interview her. Is that right?
Wow.
Objection.
Sustained.
She was, well, let me ask it this way. You don't deny that Courtney was meeting with Julie before you interviewed her, correct?
correct.
And you don't deny that you had been providing information about the case with Courtney before you interviewed Julie, correct?
Provided information that Julie and Chris were at the waterfall and I needed to interview them. Yes, that's the information I shared.
And who knows what you shared verbally, not in text messages, correct?
Objection.
Sustained.
Did you, we have text messages, Trooper Proctor. Did you share other information on phone calls with Courtney?
No,
So the only information we're to believe, you talk to her 5 to 6 times a day, the only information that you claim you shared with Courtney about the details of the investigation are contained in these texts, which we have.
Let's be
Objection.
real, dude.
I'll let you answer that. Can you answer that?
the information that I share with my sister contained within these texts, yes.
You never discussed
This is exhausting.
this case
Oh, man.
verbally over the phone or in person with Courtney?
On the phone, I'm sure there's been conversations that things that have been newsworthy items that have gone to the news. There's definitely been conversations in that regard.
Oh my God, get this guy out of here. I'm done. Get him out of here. Let me read a couple of these super chats. And again, the jury is at lunch, guys. They'll probably be back in another 30 something minutes. I don't know if we have a verdict today. I have to see what y'all are saying in here, because it looks like nearly 80% of you think we will have a verdict today. I don't know. We've only got a few hours left, because they left at 3:45 yesterday. So 80%, I asked, will there be a verdict today? 80% of you said yes. 19% of you said no. Guys, I don't know. I don't know what's going to happen. Cynthia Hartz is out just like me. Is his sister hot? If we don't have a verdict today, we're going to have to wait until Friday, unfortunately. I don't know what's going to happen. Shout out to Ray. Thanks for being here, Ray. I appreciate you. Yeah, we're trying to have some justice in this legal system. So I know you don't always get in the legal system, but wow. No court on Friday? Wait a second. Why wouldn't there be court on Friday? What's going on Friday? I think the jury wants more time away from their jobs. For this, how much are they getting paid? I'm not even going to look that up. It's going to be depressing. Yeah, no court tomorrow either. So if they don't figure it out in the next 3 hours, guys, I don't know if Judge Bev is going to force them to say, but you see, we're not even having a vote. And we spent nearly 2 hours this morning talking about this OUI charge. So if they're torn on this, I don't know. I'm not budging on my take. Y'all aren't budging on your take. So it might, I don't know. Someone said it's $6 per day. Oh, I hope not. Mark said, I'm just playing. Thank you to everyone who liked the video today. Big shout out to all 700 plus of you that liked the video. Y'all make sure you like the video on the way out, because we had nearly 1,100 of y'all in here. Also, shout out to everyone who went the extra mile and showed support over on the super chat. Les Cleaver, my guy, Libby22, SC Girl, CPE, Slim Life, New Jersey was in here. We had Trisha celebrating a milestone, Virginia Wiley, Paua Eyes. We had Nana Banana was up in here. Cynthia Hartz, Curious Coco, New York. Kara Hampton, as always. We had Casey Travis was in here as well. My guy Peter Ortiz is back at it, ready to lock Karen Reed up. We had Keep It Moving in New York. And then Ramel Rakina was in here as well. And then, of course, y'all know my awesome, amazing Amy was in there showing love. We're going to get out of here for today. Again, if y'all haven't yet subscribed, hit the notification bell so you don't miss any time that we go live. If we get a notification that there is a verdict, that the jury has a verdict, we will be back live today at some point. So I'll keep an eye on it. We just got a few more hours for them to make a decision. I don't see it happen. Y'all saw how much we were struggling over here, just trying to agree on the OUI. I don't know if they're going to have a decision today, but hopefully 80% of y'all are right. Free Karen Reed. We will see what happens. Y'all have a great rest of your afternoon. And if you haven't yet, make sure you hit that notification bell so you don't miss if we have an emergency live stream. Appreciate y'all. I will see you on the next live stream, and we'll be here tomorrow, even though there's no court. So make sure y'all tune in for that too. Y'all know what to do. Keep growing, keep pushing, keep it classy. We gone. Peace. What?